It is 1:25 p.m. and I am going to call the meeting to order and begin with our roll call, beginning with Commissioner Elovich, please.
Lisa Elovich, present. Commissioner Julie Smith, present.
Commissioner Sally Thompson, present.
Ellen Alexander, present.
Kevin Ludlow, present.
Kathy Hiley, present.
Tina Stanford, present.
Otis Cruz, present.
Mark Pola, present. Joe Pringle, present.
Melissa Freeman-Rogan, present.
Matt Bailey, present.
And our videographer, Ms. Colucci, is also in attendance. And with 9 board members in attendance, we have a quorum and can conduct the business of the Board of Parole for August 22nd of 2016. We have no other attendees other than those on the roll. And I'd like to begin with a review of our minutes from July 25th of 2016. If you've had an opportunity to review them, with the exception of Commissioner Coppola, who was excused absent, I would like to entertain a motion with respect to our July 25th, 2016 minutes.
Move that they be accepted.
Okay. Is there a second? Second, moved by Commissioner Alexander. Second by Commissioner Cruz. Please note who moved and who seconded for our minutes. Are there any other questions or discussion? All in favor of accepting the minutes as prepared for July 25th of 2016 indicate by saying aye. Aye. Any nays? And I would note one abstention from you, Commissioner Coppola?
Yes.
Okay. Thank you. Board training. Thank you all who have been participating with us in our training schedule for 2016. As you all know, we had a robust training back in May with respect to parole decision making and decision writing that was very well attended. Those who weren't able to attend, most of them have made that training up. We followed that training up with a training on early conditional parole for deportation only and conditional parole for deportation only, July 28th. The DVD is available. Are there people here today who have not had that training yet? The ECPDO? Okay. We have a DVD available, and ITS was very helpful in that process. We recorded it using the equipment, and then they created a DVD for us and pared it down to the essential portions of the training. So that's available. If you let Talissa know, we'll try to make arrangements for you to see it. Perhaps when you come to Albany for your boards, that would be a good time I would recommend for you to see it. I think it's less than 2 hours. I want to say it's about 1.5 hours, something like that. But if you can review it when you're in the Albany office, that would be even better. Then we don't have to send it around the state and wait for it to come back. So if you want to plan that for when you're... Well, we have one copy. We can always have more made. Yeah, we can have more made. So if you're unable to watch it while you're here, you can take a copy with you. Okay? All right, thank you. And we're going to continue training. The next training that I hope to put before you by video conference will likely be either on the Compass instrument and what its status is today, or sex offender treatment within the Department of Corrections and Community Supervision. So one or the other will be first in time, but they'll probably be the next trainings that we'll be scheduling for all of you. And the Compass will be to bring you up to date with what's happening with the Compass, the statewide review of the instrument that we're undergoing. They're rolling out a new version And it mostly impacts the users, the people who actually create the compass with inmates, and in the case of probationers, for them, because the instrument is used by different state agencies. DOCS has a very specific use for it, and so do other state agencies. So there's a statewide team that works with the creators, North Point, to talk about rolling out new versions, testing new versions, as well as updates that need to be made to the instrument itself. So we will hope to include in that training up-to-date information for all of you, so that we, as some of the primary users of Compass, know where it's at today in terms of its status and where it's predicted to go in the future. With respect to policy, procedure, and directive, I want to thank you all for voting on the directive having to do with interviews in absentia last month. That directive is in the process of being prepared for publication with all of the other Department of Corrections and Community Supervision directives under 8600, which is the number designated for the Board of Parole directives. So that will be our second directive once it's published. And we're just going to keep moving ahead and try to always have something for you to vote on at each board meeting, and maybe we'll have another directive for you by next month. With respect to today's business, it is in the line of policy and procedure. We want to have a conversation about a potential regulatory change, and I'm going to make that part of our new business for today. Everyone has received a confidential draft of our parole release regulation, proposed regulatory document. And what I plan to do is highlight what's new in this document from the last update, which was effective July 30th of 2014. In the first part, 8002.1, C is new language. What I think you'll find in reviewing the document together today is that, for the most part, what's codified now in this document tracks what the law requires us to do. And, to be honest with you, in my opinion, tracks what we're already doing as a matter of course and practice. What this document does is highlight our adherence to the law, whether it's the executive law that governs us or case law that governs our practice. So with respect to Section 8002.1, C tracks our practice of going through applicable factors. We all know that when we're conducting interviews, if somebody doesn't have a final order of deportation, that factor simply doesn't apply to them. But for the more standard factors, like institutional adjustment and institutional history, we've got history on everybody. We've got an institutional record on everyone. So we go through those factors that apply to each person as we interview. Like I said, we already do this as a matter of course. This highlights that, of course, excluding confidential information. 8002.2. A is a new section. It references language in the executive law that talks about our being guided by risk and needs principles, and uses specific language to highlight how we do that. and specifically as it relates to the COMPASS instrument. We all know that the instruments give us scores regarding risks and needs. And in the instance where we're denying release, this document highlights our need to explain why we're departing from a low-risk score, what would more likely be a low-risk score. I'm just going to walk through it and then open up the floor for conversation, and you can reference back to sections as you see fit. The next set of language that's new to this document is in section 8002.2b1. You'll recognize this factor from Executive Law 259. Section 1, the new language is a specific mention of the Transitional Accountability Plan developed by DOCS pursuant to New York Correction Law, Section 71.A, what we commonly call the case plan. It was called the TAP in 71 sub A, but we commonly refer to it as the case plan. So it's just specifically spelling out that among the other records in the institutional record, the case plan is one of those records that we review. As I said, formerly known as the TAP. The next new section is C in that same section, 8002.2C. We've defined a new group, calling them minor offenders. These are individuals serving a maximum sentence of life for a crime committed prior to the person attaining the age of 18. And sub 1 under C calls upon us to consider, pursuant to case law, I and double I. And then paragraph 2 highlights for our use and for the use of future board members, should this become law after a review process by the state, a reminder to us that hallmark features of youth should not be used against the inmate solely by themselves to demonstrate lack of insight or minimization of a person's role in the commission of the crime. And finally, in section 8002.3, there's an expansion of the language under denial of release. We're used to seeing language where we're told that anytime we deny release, we shall give the reasons in detail and non-conclusory terms. The second sentence in B gets even more specific, factually individualized, in addition to and non-conclusory terms. We want to get away from using terms of art and buzzwords and phrases and really spelling out for folks the facts for this particular individual. And I think, as I said, especially since our training in May, at least from my review of decisions and my time with all of you on different panels since May, I'm confident that we're all making a sincere effort to do exactly that, to be a little bit more factually specific in our reasons for denial. So I thank you for taking the training to heart and applying it in your deliberations and in your written decisions. I think our counsel's office has noticed improvement in that area as well.
We definitely are starting to see that as they are trickling through with the appeals. Definitely, it's improving. So you're doing a good job. So we appreciate it.
Okay, so we've worked on this draft for a little while. You may still have questions for me, questions for Kathy. So I open the floor for any questions that are outstanding.
I have a concern about the mandatory nature expressed in point 2A. We've seen issues in the past that have been generated by sentencing minutes, by case plan, by TAP. That has been problematic in the past, that track record. My concern is that with mandatory language, we may see that problematic circumstance reoccur. I think we could serve the spirit of this proposal very well if we make this aspirational language or precatory as opposed to mandatory. We may find that we could regret this type of language as opposed to aspirational. I do have a concern about that.
You want to speak to any concerns you may have with respect to appeals going forward?
Sure. I think certainly, we may or may not see an uptick in litigation or appeals. There's always that possibility. But I think when you look at the regulations, it really is not changing much of anything as far as what you're going to consider as far as factors. What it's really focusing on are how you render your decisions. So whatever your decision ultimately is, it is. But keep in mind that you've got to apply all the factors as much as relevant. So, I think it's going to be fine. I really do.
Yes.
With respect to the compass, we talk about individual risk and needs throughout the interview. Areas of concern, areas where they have good support, such as family. Why is it necessary to then articulate that in the decision as well? We've already discussed it, and there's an official transcript of that. Why do we need to then transfer that into writing?
Well, I think it's because when you give your reason, if the reason is infirm because it's in conclusory terms, or it's not factually specific, then it's not always easy for people who aren't familiar with our practice to know exactly what it was we were thinking about or we were giving greater weight to in having a concern for a person-specific risk. One of the things that I've tried to do to educate the public is to let people know that the compass was never intended to be the sole indicator of risk or need. It's simply a tool that the state has purchased to assist, and it really wasn't even initially meant to assist us. It was meant to assist community supervision in determining the level of supervision that the person would need. We've sort of adopted it as the law was expanded to tell us to be guided by risk and needs principles. But the fact always has been true that we find risk and needs in all of the records before us, including the interview itself. And so every chance I get to talk about risk and needs, I remind people that the compass isn't it. It isn't everything there is to know about this person's potential risk and potential needs, or even likely risk and likely needs. That we find that information in a host of other things, including the other relevant factors. And when we do, then it behooves us under the law as it's written now to say what it is that we still find risky or high risk or an unacceptable risk about a release of this person. It behooves us to say so. So in that sense, I piggyback off what Kathy said. We have to do that anyway. We have to say what it is about this individual, the way that they're presenting themselves today, all of the other factors as they apply to this person. We have to say right now what it is that makes them high risk or their release incompatible with the welfare of society, or what it is that would so deprecate the seriousness of the crime. What is it about this release? We have to do that anyway. So to the extent that what we're finding in the course of the interview with the person, something that they've said, some way that they've presented themselves, or in the records before us that make us tend to not have confidence in what the compass is saying, it's fairer, it's more transparent to say what that is. And that's what this is asking us to do. We have to do it anyway. We have to be specific about our reasons for denial. But where it departs from what the compass is suggesting, it makes sense, because I think too many people in the community are under the inaccurate assumption that the compass is the be-all and end-all, and that it's this perfectly predictive instrument, which it never was intended to be. And North Point would tell you that themselves.
Just, in terms of what you were just saying about the compass chair, that it's certainly not the be-all and end-all. It's one of many things that we look at. Putting it in this section of the regulations rather than just one of the factors that we consider seems to elevate it to a certain extent. And I guess I'd like to first know whether or not there's been an assessment done on the compass. When it first came out several years ago, North Point had told us that there would be some type of an assessment to see how accurate the compass is in terms of recidivism based on people that were low risk that we let out, and some of the reliability factors of the compass, and that go towards whether or not parole officers rely on it as something when they supervise, or do they override it. And I guess I'd like to know whether or not an assessment has been done on it so far, what type of assessment will be done in the future to add in some of the factors that we have discussed in the past as issues with the compass, such as vulnerability of the victim, multiple victims, whether or not there's torture involved in the crime, and some of the aggravating factors that we now list in our decisions as things that contribute towards a higher risk factor. Will those factors now be part of the compass, and if so, when do you expect to see that happen?
Well, I can't give you a timetable for future research on the instrument as it exists right now, but I'm not aware of any research that the state possesses since the state began using it. What I can tell you is that the area offices are now reporting to central office of DOCS the number of overrides. I don't know if it's broken out more specific in terms of why, but I know as part of parole stat, which has been revived, they're reporting when they override what the reentry compass has suggested as a supervision level. So that's information that we can get, and certainly as it's being updated, we'll be intimately involved in those updates. And the other part of this section that I didn't highlight to your attention that I think is important is it also spells out other risk and needs assessments that are available. I'm aware of the fact that when people are in sex offender treatment, for example, they are assessed And they probably are assessed more than once. They're assessed before they begin the treatment to determine the length of the treatment that they get. And as you all probably know by now, there are different lengths of programs depending on a person's risk as a sex offender. Some programs are a few months, some programs are more than a year. And then they do an evaluation at the end of it. When we start to get those records on a regular basis, that's something we can use, for example, as a risk and needs assessment to review and make a reasonable and appropriate decision on someone's suitability for release who happens to also be a sex offender. We may also have within our records other assessments, other information. Like I said, we get risk and needs information from a variety of sources that are put before us at the time of the interview. And so it allows us to use those as well without also saying when we depart in those cases. And I think the only reason why COMPASS has been selected for us to highlight when we're departing from what would appear to be a low risk score is because we do have this overarching responsibility already existing in the law to be guided by risk and needs principles. So one of the fair criticisms that we've gotten since that law was written was, well, where are you being guided by risk and needs principles? And if the only answer we can give them is, or has been given, was COMPASS, now you have the community expecting that COMPASS does mean more than what it means. So the best way I can answer your question is by saying we have a responsibility to do what the law says we will do, which A is to be guided by risk and needs principles, to apply our standard, to apply the factors, and to be very fact specific in terms of our interviews and our decisions. So given that, I think this is not, again, asking us to do something that we don't already have a duty to do, but part of it is to do what the law requires we do, and the other part of our responsibility and our state partners' responsibility with us is to educate the public on how we do our job, and that while we're using the COMPASS as a tool, in part to be guided by risk and needs principles, that the risk and needs are found in a variety of other places too. And when we can say responsibly, when we're not relying on an assessment that the COMPASS is suggesting, then it gives us an opportunity to highlight the things that we are relying on. It might be the interview itself. It might be the institutional behavior that for us says the person is a higher risk. So I think that we're following the spirit and the letter of the law, as well as educating people by writing more detailed decisions, and specifically in this respect as well, because I think when we're more specific in our decisions and there's more transparency, people can understand why we've rendered the decisions that we have. And whether they like them or not, it makes it harder for them to second guess them because we've laid out our reasons in detailed, non-conclusory, fact-specific terms. Any other questions?
Just a couple of questions. And I don't know if this is just a matter of logistics or not. What's the difference, and maybe this speaks to what Lisa was mentioning, what's the difference between it being under 8002.2A, it says risk and needs assessment, factors to be considered, and then it's A there, and then again, B, we have factors to be considered, and they're numerized there. What's the legal, I don't know, is there a difference there?
Well, if you remember, the last regs that were effective as of July 30th of 2014, our counsel at the time and I inserted the COMPASS, if any, and the case plan, if any, as factors. We just put them in as factors. But again, the criticism, and it may be a fair criticism, is that being guided by risk and needs principles is really more overarching than just having it listed as an additional factor. And so separating it out and putting it in A, and then adding to that the specific language about individualized reasons for departure really does highlight it in a way. It doesn't give it more weight under the law because the weight is for us to determine in each and every case. But it highlights it in a way that's more consistent with it being separately referenced in the executive law. It was never listed as an additional factor. It had its own section in the law. And so we're really more in keeping with the way the law reads by separating it out in this version than we were when we put it in as a factor. Because if the legislature had wanted it simply to be a factor, they would have made it a factor. And that's part of the, I think, fair criticism that we've heard since our regulations. And I'm sure it was part of the public comment on it. People couldn't understand why we were just throwing it in as a factor.
But it is a factor. If we do this, it would be a factor.
Oh, it is, but it's being highlighted in a different way. As opposed to just being under B, where it was in 2014, now it's in its own section, as I said, because we are being guided by risk and needs principles. And if we use something else, and just so I can finish my point, if we use something else, say 2 years from now we decide we don't want the compass anymore, we want to use a different tool, then we'll have to update our regulations. It's just that simple.
Do they have to say compass? Why can't it just say a risk and needs assessment tool? Why does it have to say compass?
Because
it's almost like saying we prefer Wheaties over checks.
I know, but it is what we're using.
Because that will change, you know that.
And
compass
it may.
Could change your name, and next thing you know it, the corporate structure changes,
and then we'll just do this again.
The other question I had was, in the first sentence, the board shall be guided. Shall is like the strongest word. I think that's what Kevin was talking about.
But that's how the law reads.
Is how it was before?
It is. This language wasn't in this before, but this language is in the law. Okay. It says shall be guided.
Shall be guided by was?
Yeah, I'm pretty sure.
I was trying to look it up real quick, but
yeah.
The word shall is finite. But does that make it as strong as the EEC language? Because then, right, you have to overcome an EEC. So then compass becomes an overcome if you decide to hold.
We are not creating a rebuttable presumption.
Okay. Well,
I do not believe that we're creating
shall be guided by. I didn't know if that does kind of imply.
No, because the language mirrors the law.
Right.
Well, in this instance, of course, the difference between 259 and this proposed regulation is it is insisting that the decision be written in a particular way. Now, 259 does not require that. 259 says we shall consider various factors, but it does not make the jump to dictating how the decision is going to be written. That's the critical distinction. Now, I appreciate all of the conversation that's been offered here today by Chair and Council. I'm drawing on 13 years of conducting parole interviews, and my sense is that we still could do this with aspirational language. We could achieve the same thing. And that would allow us the latitude to proceed. And if we find, as you say, Chair, that at some future date we need to amend, we could amend to shall at that time.
You want to read this section? Sure. I was just going to point to 259C, which is not actually 259I, where it does list the factors, but 259C4 actually states that the board shall establish written procedures, and I apologize because I think I need glasses, but shall establish written procedures for its use in making parole decisions as required by law. Such written procedures shall incorporate risk and needs principles to measure the rehabilitation of persons appearing before the board, the likelihood of success of such persons upon release, and assist members of the State Board of Parole in determining which inmates may be released for parole supervision.
Mm-hmm. So these are the written procedures that this contemplates.
You don't think that shall incorporate, meaning together, shall incorporate is not as strong as it shall be guided by. I mean, just my I don't know. I could be wrong. I'm not a lawyer, but that's all. I mean, I don't know. You know, I'm not a lawyer, so I would leave that to the lawyers. But shall incorporate a risk and needs principle in the measures, and shall be guided by, just seems a lot stronger to me. But if if the courts, if you believe that it wouldn't be a finite determination and open us up to say, oh no. See, I always say that you can disagree with my decision, but I know what I write in my decisions. I challenge any judge to say they didn't know why I made the decision, or why I wrote that. We make a decision. I never make a decision. But why I wrote it that way, if I was the one that wrote it. Because even the inmate will know. I don't use, words that they don't understand. I won't understand those words. But you could disagree with my decision. But to say that you don't know why, I would find it very odd. Because I always write a little sentence in there that what outweighs what for me. I always do. So it wouldn't be that much more, but I'm just questioning, if it says shall be guided by, then can somebody say, well, you allowed this other factor to guide you too much because you should have been guided by this more. That's all I'm saying. Is that a problem?
I don't see it as that, because we're going to make arguments for strongly written decisions. We will make arguments, and we will point, hopefully, to your adherence to the goal of writing more fact-specific decisions. But I have to say that hasn't always been so. And maybe some of us have not always written our decisions as well as you believe your decisions have been written, to be clear to people what it is that we're relying on and what it is that we're giving weight to in fact-based, non-conclusory terms. Like I said, just to simply reference institutional record, release plans, case plan, compass, isn't enough. We need to say more. We need to be fact specific. And to the extent that we haven't always been, I think has raised cause for concern, and we have an opportunity to address that concern by saying, yeah, we're going to do this. We're going to do what the law required us to do.
The other thing that I think is really, 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 really critical. I mean, we don't even know the success of Compass and the scores. And the Compass that we see is completely different and used differently than the field staff uses it. They don't use it for the same thing we're using it for. They view it differently, and they have their reasons for overrides and everything else. And I was here when they were doing it. I was in those meetings with the chair. I was in those meetings with the regional directors. With the parole officers, I know exactly why they were doing what they were doing and what the concerns were when Compass came out. Because there could be mistakes. Even inmates raise it. Look, my mother writes me every day. Why does it say, I have no family support? I mean, there are mistakes. We're human. But some of the things that I don't understand, maybe I should be, more familiarized with some of the issues. But for instance, if you were overriding, say, somebody's absconder level, and you consider, okay, well, maybe I don't have all this paperwork in here, but I know that you have 2 escape attempts, and you've been convicted of escape twice. We had a guy last week. He was convicted of escape. He escaped from prison back in, I don't know, maybe it's the 80s or whatever. I think he had 2. His absconder level was low. To me, that seems kind of odd. When you've already escaped from prison twice, a local jail, and then an attempted escape from a state prison, and your absconder level is low, to me that calls into question the validity of the instrument and why it's that way. So can I then point to, while your Compass level says that you are low for felony violence,
Yes.
this is the 3rd time you're in prison for beating up your wife?
Absolutely. And that's what this is asking you to do.
So, because again, you might disagree with where you're coming from, but when the record says something slightly different than the Compass, I would have to tend to argue with whoever wrote that report, because it doesn't seem, or if somebody's absconder level is high. We had the one guy who was blind, He had one leg, he was in a wheelchair, and he was high for absconding. And even he said, where am I going to go? He couldn't even push himself in the wheelchair. So Lisa's point is valid, I think, that we don't even know how accurate the tool is. And that's sometimes frustrating.
But you're making the point. You're making the point that, and you have the information to provide the reason for a departure. And we're just asking you to say so.
Most of the inmates, it's my experience, object to the accuracy of the compass in one fashion or other. And if we are to use mandatory language, that we should recognize that the offenders themselves find many issues with this instrument.
Yeah.
We discuss it on the record.
But don't confuse what's mandatory. What's not mandatory here is that you will go in the direction that the compass is telling you to go. What's mandatory is that you will explain when you don't. And I don't think that's a big leap for the reasons that everyone is voicing. We always know when we disagree with it. Why? And all we're asking is that you say that. Because that's not something that somebody just reading a decision would know. Because you have to remember, most of our decisions are public when we make them and once it's been served upon the inmate. When people are calling, when the media is calling the week after a decision is rendered, they're not getting the transcript. Right. All they get is the decision. And if the decision doesn't really give them any detailed information, they don't know what it is we're thinking of. So when we've seen somebody who's been in for 30 plus years and they've got lots of community support and people rallying, they won't know anything about why we denied that person for months specifically, unless the decision says so. And that's what we're asking. No, they don't get the transcript because the transcript isn't available.
2 weeks.
They don't get it that fast. It has to be reviewed, redacted. People have to do FOIL requests. The only thing that people can get quickly is the decision itself. So anyway, they can get it sometime down the line.
But they don't always.
But I'd like to suggest we're kind of going far afield. I'm trying to answer the questions and concerns, but I don't want to start talking about transcripts now.
And my last question on that, and then I won't have any more questions, I don't think. Because I think this answers for both the sections that we're talking about. The final paragraph B, denial of release. So where it says reasons for denial of parole release shall be given in detail and shall, in factually individualized and non-conclusory terms, be addressed how the applicable factors listed in 8002.2 were considered. Does that mean we have to list out each and every one of them? It says listed in 8002.2, considered in the individual's case. It says, it almost makes it sound like I have to list each and every single one.
Don't we do that now?
No, I don't list every single one of them. I list the one that I'm concerned about, but I don't list this one I'm concerned, this one I'm not, that factor you're okay. I mean, it almost makes it sound each and every one of them. Could an argument be made that, well, he didn't discuss my performance? I'm asking the question.
Come on now. We know, based on our training, that we have to expand our discussion of what we have considered. That is the law. That is part and parcel of the many de novos that the courts have issued against us. They're not getting the kind of review of the pros and the cons that we should be giving under the law. And I think, as I said, people are doing a better job. What we did in the past isn't going to suffice. Using conclusory terms, institutional adjustment, case plan, risk and needs assessment. You were covering the bases already, but you weren't doing it in fact-based terms. So this is again codifying the training and the direction of the case law. And I don't think it's asking you to do anything that we aren't already doing now, post-training, and in the advent of the case law. I think everybody is doing this.
Individualizing it, but not making it so specific that you set up de novos, like saying, you've had
Right.
40 arrests.
It had to be
Multiple.
wrong.
Well,
It's
and,
just,
right, and that we have to be careful of. I don't like it when I don't want to run the risk that I've miscounted or I've counted something that I shouldn't count. So, you know, I mean, but I think we're all professionals. We're all good writers, and we understand where we need to be general and where we need to be more specific. And I think our training was a good first step in talking it out amongst ourselves to figure out what language meets the goals and what language meets the standards that the law requires.
I think just to answer Mark's question, I think because the standard says applicable, I would read that to mean that I don't have to list every factor. I list the factors that are applicable to my final decision.
Applicable covers my concern.
Yes.
Correct.
That's
And that's why we have it in there. Because you don't have to say, well, you don't have a deportation order, so that doesn't apply to you. You're not on work release, so that doesn't apply to you. We only have to talk about what applies. And that's what we're doing anyway.
I just want to say that I agree with everything you said about the need for our parole decisions to be more individually factualized and more detailed. And I think a lot of us have been doing that. If not everybody is now doing that. And that is an important thing for people to know why they're being held and specific reasons. That's absolutely a necessity. I think when you redo regulations and you use certain words which can be taken, which are subjective types of words, you have to be careful the way you word things, because I think it leaves a lot of room for misinterpretation by people that are reading the decisions, by the judges, and even by the people that are writing the decisions. So I think, you know, it does, the last paragraph, B, does warrant further discussion on what exactly is meant by detail, the word detail, what exactly is meant by factually individualized, so that there is some uniformity and that there is a sense of knowledge by the people that are reading the decision, the people that are writing the decision, and judges that are reviewing the decisions on what that means, because it leaves a lot of room for interpretation.
Well, we're writing it, and we get the first crack at interpreting it. We began interpreting what we mean by this language with the last training, and if we need more trainings, we'll have more trainings so that we can talk amongst ourselves and be in agreement with what would satisfy this language. And then our counsel's office will defend us when any appeals come that try to interpret this language in a way that we did not intend. We're the authors of it, so we have the first opportunity to say what we mean by it. And I think, like I said, this isn't in a vacuum. This, to me, codifies the conversation we've already begun among ourselves in our training with the assistance of our counsel. So I don't think anyone can tell us how to interpret it. We can say what we meant, and we can defend ourselves against challenges that suggest that it meant something else. So, do we need a break before I call for a vote? Okay.
We vote on this, is this exactly what we're voting on? Because it does say draft subject to change, but that's not.
This is what we're voting on, but understand that when it goes through the SAPA process, there is a public comment period, and then we can review, because remember what we did the last time. We presented a draft, you all voted on it, it went to downtown for SAPA review. During a public comment period, we received hundreds of submissions. At the end of that public comment period, we made the decision whether or not we would make any changes. We did not make any changes, and we filed it.
So after the public review
There may
period is
still be an
over, it has to
opportunity.
come back for one
Right.
more vote.
And there may still be an opportunity for changes at that point. And maybe by that point, we will have had more training on Compass, more public education, maybe even some more board training on our decisions ourselves and how we ourselves interpret this language, so that there is consistency among us.
And also, are we voting on the entire thing as a whole, or are we voting on each change because there's a lot of changes?
We're voting on the entire thing as a whole.
And the vote today, is that to merely submit it for SAPA review?
That's right.
Or are we endorsing the exact language in here and in addition for SAPA review?
Well, I think if we're presenting it for SAPA review, it is an endorsement. So if there are those among you who cannot do that in good conscience, then you would vote against it.
And if someone feels that they're not ready to vote on this yet because they want to look into it further, is that also something that you would be open to, or is it just a yes or no vote to that?
It's a yes or no vote today, so we can get the review process started, because we're prolonging the public comment period and everything else the longer we delay. So I'd like to get it started. Like I said, anyone need a break before we vote? Okay. Is there a motion on presenting the regulations for review?
A motion to present it.
Thank you. And I second. Any other questions or discussion? Okay. All in favor, and I need a show of hands, please. All in favor for presenting the regulations for review pursuant to SAPA, please indicate by saying aye and raising your hand.
Aye.
We have 6 votes in favor. Okay. All nay, please vote by show of hands. Nay. And 3 votes against.
I'd like to qualify my vote. I respect the effort that's been put forth here. I understand that public disclosure is important. We need to show that we are applying the law in a particular way, and I respect the effort that's been put forth. However, I think there's a slightly better way to do this, as I tried to delineate in my earlier discussion. So with that qualification, I respectfully dissent on the vote.
And I
Thank you.
would also agree with Commissioner Ludlow. I'm not dissenting because of the actual part of what's in here. I do believe that our decisions need to be based on more facts and more individualized. I do believe that youth and age are factors that should be considered, and I do believe that risks and needs are something that are important and that need to be considered. I'm dissenting because I think that the compass can be a better instrument than it is. I think that if the compass were more accurate and did reflect vulnerability of victims, number of victims, and whether or not there's torture and sadism involved, I think it would be a more accurate and more reliable instrument that could be a real guide to us. And I hope that one day the compass does become that. My other dissent is on portions of the regulations that I believe are somewhat vague and may be misinterpreted by judges and others, but I do believe in the spirit of the regulations, and I intend to make my decisions as detailed as possible.
Thank you, and I do appreciate that. Commissioner Smith, anything you want to say?
I would piggyback on both Commissioner Wendell and Commissioner Ehrlich. I just think the way it is written is putting undue weight on the compass. I think if we're going to put that much detail into what we're going to consider, then that needs to be considered in every factor. Because if we, they have wonderful release plans, but we deny, we should be articulating that too.
And we do. I do.
think there's too much weight in this section put on the compass.
No, I think, yeah, I appreciate all of your comments. Thank you all for the vote. But I think that we're, like I said, I believe that those of us who are really trying to evolve and become better writers of our decisions do capture the specific reasons for our denials. And so I'm seeing that more and more. And I think even when there are other factors that outweigh the compass, we're doing a better job in expressing those factors. So I thank you for that. I thank you for the effort that you're all making to do this. And we'll keep you posted as this progresses through the process. And maybe this time, unlike the last time, I'll share a few of the letters we get during the public comment period. The last time, our counsel and I bore the weight of reviewing those letters individually and those submissions. Some of them were briefs, actually, about changes that people thought should be made to our law, so that you can see how the public views our work, and they may make some comment that we may actually want to integrate into the final revision. So again, thank you for that. I will keep you posted as it progresses through the process and bring you back information as we receive it. Thank you. Okay. I don't have any other new business. Is there any other item of new business that any of you have that you wish to discuss today?
Ask a request.
Yes.
I've done this since I've been here, so it's not anything toward anybody here now, but in the future, when we have things like this, we have to turn around, especially when it's already language, can we please have underline for the new language and strike through with the old? That is standard practice, and it makes it very difficult to try to compare the two. And I agree with Lisa, there's lots of changes, but guess what? To try to figure out which ones they are real quick before a vote. I mean, obviously, in most cases that I've been involved in, you get it for a minimum of 3 days, you can do all that. But underline and strike through makes it so much easier to weed through. What are we talking about? And if we can just have that, please, because it just makes it more, it gives me more confidence that I know what I'm doing. So I've asked that since I've been here, and it's never been done. I don't know why. And for all of you who are lawyers, save just a few of us, I know you all know that because that is, part of how you write laws. So if we would please have that, it's a strong request on my part.
Thank you so much. We will do our best to comply. All right, I'm going to move forward then to correspondence, announcements, and invitations. As you all know, pursuant to emails that went around, former Commissioner Cristina Hernandez is now the statewide director for reentry for the Department of Corrections and Community Supervision. We wish her well. We will miss her work ethic and her participation with us on panels, but I make that public announcement today. Hopefully we can honor her with a plaque for her years of service to the Board of Parole at a future meeting. We're trying to order that now, and we'll make you aware of the month that we think that we can invite her and actually present that. I also have 2 letters. One is actually a postcard and one is actually a letter, and it's dated 8/10 of 2016. Why are you so cold and callous in not granting parole? especially when someone has served 40 years like John McKenzie. 10 times you rejected him. Why aren't those incarcerated treated with respect if they have been a good inmate? You make it hard for people to change if it's all meaningless. What you just did is worse than any crime committed. You no longer serve any legitimate purpose. I've decided to read this today because you need to see the good and the bad. I've been making it a practice to read thank you notes and success letters and things like that. But, we get other mail as well, and I may choose to share some of it with you from time to time. This next letter was dated July 29th of 2016, and it starts with a quote. And I don't know if this is an original quote of the author. I tend to think it might be because it's not, no one else is given credit for it. And the quote that it begins with is, "He who has his hand in the water is not like him who has his hand in the fire. Our circumstances greatly affect our reactions. It is easy for one in a solid position to critique the manner of one less fortunate, or to claim that in such a position they would respond better," unquote. Chairwoman Stanford, this is, and the person gives their name. I sat before you on July 27, 2016 at my last parole hearing. I just needed to thank you and Commissioner, who will remain, well, I'll say it, and Commissioner Cruz for making the decision to formally release me. As I stated, I will not fail or come up short as I return to society. My life work, goals, and aspiration are to be a model citizen and law-abiding the rest of my life. In fact, when I become employed and start to speak and assist young people, I'll surely keep your office abreast of my work in the community, okay? Promise. Again, I thank you from the bottom of my heart. I was finally able to tell my children, grandchildren, when to expect to be able to hug and hold me again. P.S. Chairwoman Stanford, my life is and will be forever changed for the better. Thank you. And then it ends with a quote. A mind operating in a body improperly nourished is deficient, as a body operating with a mind inadequately conscious is handicapped. So we'll see if we hear good things from this person in the future or not. But again, I like to share these when I get them. If you get letters that you'd care to share publicly during the board meeting, let me know, and I'll be happy to do so. Okay. If there's no other business, I'd like to entertain a motion to enter into executive session to discuss confidential information and adjourn the meeting at the end of executive session. Is there such a motion? Motion made by Commissioner Capola. Is there a second? Second. Second made by Commissioner Alexander. All in favor of doing so, please indicate by saying aye.
Aye.
Any nays? Any abstentions? We are in executive session. Thank you.